Let me introduce Molly O'Brien here from LA, has a law firm that works through surrogacy agreements in the States. Natalie Gamble and Helen Prosser from Natalie Gamble Associates and their sister organisation, Brilliant Beginnings, who do similar but quite different here. Yes? Mm-hmm. So the point of the session is a bit of the contrast between making agreements in the States, or in California in particular, and what happens when you make a surrogacy agreement in the UK, and the process by which that is made, and what happens post-agreement, and what can happen and what can't happen. So on that basis, and following on from what we've just had, I think start with the US, because that follows on directly from some of the stuff that's just been talked about for those of you who were in the last session, and then we'll move on. So in that order, yes?
My name is Molly O'Brien. As Kirsty said, I am an attorney and I practice in the state of California in the United States. I've been in the field of surrogacy helping people since 2004. In fact, I just realized that this week is the start of my 15th year helping people. So that's really exciting for me. I started at a surrogacy agency and an egg donor agency, and then I became a lawyer. So I have a really interesting perspective about how this whole journey fits together. The contract has a lot to do with your agency experience as well. I'd also really like to touch on contracts in California and how they affect you when I have international intended parents who are coming home and working with you to get their parental order as well. The law in California is beautiful. It's so easy. The legal is the last thing you need to worry about doing surrogacy in California, because we have really straightforward laws, and as long as you follow that law, you have nothing to worry about, because the parentage order, at least in the States, is entered into. But there are certain things that we need to do to set you up for success. So it's really important that you speak to a lawyer in the UK before you do surrogacy in the US, so that we can set you up properly. And what I mean by that is some parents find it better to work with a single surrogate mother in the United States because of the assumption of parentage here in the UK. You can work with married, but it can complicate things, so talk to a lawyer here. We also want to put certain things in your agreement so that when you return home, it's easier for you. So make sure you talk to somebody and that we're all working together as a team so that your rights are protected and that you don't run into any problems when you return home. Does that make sense? Good, okay. Let's talk a little bit about the content of the agreement. In the United States, you're going to see two types of things in the contract. One is going to be your relationship aspects, your more warm and fuzzy, touchy-feely, I like to call it, the things about your agreement. And then the secondary part is going to be financial. Now, the financial component affects you guys back here, so we have to be sure to have, again, compliance so that you don't run into any hiccups once you've returned home. So the warm and fuzzy, touchy-feely things that you're going to see in a contract are ensuring that the surrogate always follows the doctor's orders. We want to make sure that she is taking good care of herself, because her health and the health of your child is the utmost importance. So if she doesn't understand what the doctor wants her to do, she has to ask questions. You're also going to see the surrogate giving up dietary restrictions, lifestyle restrictions, and travel restrictions. The laws regarding surrogacy in the United States are different in every single state. So we want to make sure that she's not traveling to a state where surrogacy is prohibited or where she could run into any problems. Because if the birth were to occur there, then you would have a whole heap of problems when you're trying to come home. So we like to have travel restrictions in there for that reason. You're also going to see a really clear discussion on how the parties feel about termination of a pregnancy or reduction of a pregnancy if something were wrong. And the reason why you want to definitely have that clear and upfront between the parties is because if you don't feel the same way and something does come up, it could be really problematic if you have a surrogate who's not comfortable terminating, but you want her to terminate. I know that's not fun to talk about, but it's something you really need to search yourself about so that we can be very clear in the legal agreement about it. The legal agreement's also going to make sure that the surrogate updates you routinely. about doctor's appointments, about how she's feeling, that she's checking in with you, because you need to know these things, and you should be getting ultrasound pictures and so forth. And I remember at the last session, somebody was mentioning having a really good relationship with your surrogate so that she can Skype you in for, doctor's appointments and things like that. That's a really great tool. Building a good relationship with your surrogate will ensure that you're always updated on things. We also want to make sure that you're allowed in the delivery room for the delivery of your child or children, as long as the doctor says that it's medically safe to have people in the delivery room. And then you've got the whole financial component of the contract, which is going to deal with the fee that the surrogate receives, any additional compensation that she might get on a monthly basis for her routine expenses. What happens if she's placed on bed rest? We want to make sure that she's getting some help around the house so that she's not stressing the pregnancy. And then lost wages, if she's entitled to any of that. Those types of things will go in there. Now, if you're working with a good agency, you're going to get a very clear description of what the surrogate's benefit package is from the beginning. So what's really good is you'll see that that's just translated into legalese for you. And in a good relationship on a good team, you're not going to see any financial changes at this point because everybody's already seen it and agreed to it ahead of time, which gives you the peace of mind of knowing the surrogate's not suddenly going to turn around and ask for more money, which is obviously a very big concern for a lot of intended parents. So anyway, you've got those two big component parts in the contract. That's going to not only be the case in California, this is going to be the case in many states. But if you're working in a different state in the United States, you need to talk to an attorney who's licensed in that state so that they can tell you if there are any specifics that you need to deal with in the contract to comply with that state's law. Does that make sense? Cool. So that's kind of everything I wanted to cover with the contract in a very general Reader's Digest version. But let me pass it over here to Natalie, and then we can kind of all talk about how we work it together.
Brilliant. Thank you, Molly. And so we help with the legal side of things for parents here in the UK, and a lot of that is helping people who go overseas. But what I'm going to talk about this afternoon is how surrogacy agreements work around surrogacy arrangements here in the UK. So surrogacy is, in essence, it's an agreement. It's an agreement between intended parents on the one part and the surrogate on the other, that the surrogate is going to carry a child for them, and then when the child's born, that child will be the child of the intended parents. Now, at the moment, the law in the UK allows surrogacy, and it has a process for resolving the legalities kind of after the end of the process, but it doesn't recognise that agreement in a kind of upfront way. So at the moment, UK law says that the surrogate, the woman who gives birth, is the legal mother, and if she's married, then her husband or spouse is the other parent. And that's irrespective of what everyone has agreed. And the intended parents then only become the legal parents of the child once the family court makes a parental order. And that usually happens around about 6 months after the birth. And the essence of what the court is ratifying with a parental order is not the agreement that everybody entered into at the beginning, but the fact that the child has been born and handed over. So UK law also explicitly says that any surrogacy agreement is unenforceable. So in other words, the law gives you no protection if things go wrong. So if you're the parents, you can't take your contract to court and ask it to enforce the handover of your child. Equally, if you're a surrogate, then you can't sue your intended parents if they don't pay you the expenses that they promised. So what happens in the UK if there is a dispute between parents and a surrogate? Well, I mean, the first thing to stress is that these kinds of situations are incredibly rare. So there have only been 5 reported UK cases which have ended in dispute about who should care for the child. And there have, in comparison, been well over 1,000 successful UK surrogacy arrangements. So that's a success rate of more than 99.5%. Unfortunately, we are seeing that disputes are getting more common. For many years, I used to tell parents there had only been 2 reported surrogacy disputes. It's jumped from 2 to 5 in just the last couple of years. And interestingly, those 3 most recent ones have all involved informal, independent arrangements. But overall, what we see is that surrogates don't frequently change their minds. So where disputes do happen, UK law doesn't give the surrogate a right to keep the baby. That's a really common myth. In fact, what happens is the family court will decide what's in the child's best interests in terms of who should raise that child. And statistically, with only those 5 cases to go on, the court has proved that they are more likely to give care to the intended parents than to leave the baby with the surrogate. So UK law also makes it a criminal offence for a third party to be paid for negotiating a surrogacy agreement. And what that means in practice is that UK professionals have to be really careful about the kind of help they give at that key stage of putting an agreement in place. So if you're intended parents or you're a surrogate, you might think it's very sensible to go and see a lawyer, to put things in writing, make sure you've covered everything very clearly in the way that Molly's described, and that everything is kind of clearly laid out. But unfortunately, that's not possible in the UK. So solicitors commit a criminal offence if they negotiate a surrogacy agreement on a professional basis. So those in the UK who are working with non-profit organisations do get some help with that process of putting an agreement in place. So COTS, Surrogacy UK and Brilliant Beginnings all require their teams of intended parents and surrogates to put things in writing. They provide them with a template agreement and they provide some kind of support with going through that agreement. And Helen's going to talk in a minute a bit more about how that works in practice. Everyone else, if you're not working through a non-profit organisation, kind of has to muddle through on their own. And most people going through independent arrangements find a template probably floating around online, and they do it themselves. And it's often hard to explain the logic behind a law which stops people accessing professional help with something that's so key and so important. And when I speak overseas, it's when I say that, that's what kind of draws the gasps of horror from other professionals, because they know that this process is so key to protecting everybody that's involved. We also find it incredibly frustrating that every time there is a surrogacy dispute, the family court says, well, why didn't you get professional advice? Why didn't you put things in writing? Why didn't you do this properly? And I think the reasoning behind the law is that in the 1980s, Parliament really wanted to stop surrogacy from happening. And the hope was that if people couldn't access professional help, they just wouldn't do it, and surrogacy would disappear. And of course, that policy has failed. Surrogacy hasn't gone away. It's got bigger and bigger. And it's now very clearly here to stay, so we need to kind of wake up and deal with that properly. And I often feel that the whole approach of UK law is a bit like closing your eyes and putting your fingers in your ears, and, you know, while a surrogacy arrangement is happening, and then only kind of reluctantly to provide a remedy at the end if everything happens to have gone okay. And, you know, we now know that disputes don't happen very often. So what we need to do is to shift the focus more to supporting people so that they can enter into sensible, ethical arrangements in a much better way. So what should the law say? Well, it seems very obvious to us that the law should allow people to access whatever professional support they need when they're putting in place an agreement. It helps set strong foundations, it enables everybody to record their expectations with clarity, and it's simply obvious that doing that is going to help avoid problems. We also think that agreements should be legally recognised in the UK. So instead of making an order which recognises the handover of a baby, we think the family court should make a pre-birth order which recognises everyone's intentions during the pregnancy. And if everyone gives informed consent, the intended parents can then be recorded on the birth certificate. So a little bit like the way it works in California. That's going to make the law simpler for the overwhelming majority of surrogacy cases where everyone agrees. And most importantly, it's going to be in the best interests of children. So ending this very long limbo period that happens after the birth. And it's important to stress that recognised agreements are not necessarily the same as enforceable contracts. So if there is a dispute in UK surrogacy, the family court can, if that's what we want, still be able to decide on the basis of what's in the child's best interests. So there can be flexibility to the circumstances if there's a problem. But those kinds of disputed cases are incredibly rare, and what we need to do is flip the presumption the other way for the 99.5% of cases where everybody wants the intended parents to go on the birth certificate rather than the surrogate. So it's really about changing law so that we're recognising agreements properly. So I'm going to pass over to Helen, who's going to talk about that process of putting an agreement in place.
Yeah, so essentially, I mean, why bother? Why bother putting together an agreement if none of it's enforceable? And I think it goes to a lot to what Molly was saying. It's about setting down everybody's expectations. I'm going to talk just very briefly about what you might want to think about covering in an agreement in the interim period before we have this magical law reform that's going to happen, and when you need to agree it, and probably as well when you need to think about reviewing it. As many of you will have seen, there's now some brilliant guidance on the .gov website, which gives intended parents and surrogates and professionals here in the UK some step-by-step guidance on how to approach surrogacy. And within this, there are lots of details on what should be covered in your agreement. We were very pleased to be a part of the collaboration with all the other non-profit organisations here in the UK and the Department of Health to get this drafted. And it's a real step in endorsing surrogacy here, as well as giving everybody some pivotal advice on what to be thinking about. So although your agreement is not enforceable here in the UK, it does galvanise everybody's thoughts, everybody's hopes, everybody's expectations for the surrogacy ahead. Surrogacy is for the long term, and sitting down and working through the detail of the what ifs and the what nots is just critical. Putting things in writing simply focuses everybody's minds on the details, as well as giving everybody the opportunity to talk through alignments and inconsistencies, not just rationally but objectively, so that when you're in that situation, although you don't have the letter of the law to fall back on, what you do have is that dialogue that's already open, and you've got the opportunity to have thought things through rationally. All of the things that Molly was talking about earlier in terms of what is in a US contract, we would want to see here in an agreement with your surrogate and the intended parents. So, looking to who is going to be involved, and maybe not just the key players of intended parents and surrogates and the surrogates partners, but are there going to be other supporters who are going to need to be involved? You don't have the letter of the law behind you to galvanise some of these details, so it's good to just make sure that anybody who's going to be pivotal to your relationship is cited in some way. Details of how the conception is going to take place, how embryos are going to be created. If you're working with a traditional surrogate, how is the home insemination going to work? Which clinic? How many cycles? The number of embryos that you're going to be transferring or you're hoping to transfer. All of the pregnancy arrangements, the surrogate's health and well-being. What do you mean by, a healthy lifestyle? It's important to drill down into as much detail of that as possible. Who's going to be giving the emotional support? Molly was saying about communication and that kind of information. What information are you going to need throughout the pregnancy and even in the build-up to the pregnancy, so that you've got that, firm bedrock of trust and openness that you can fall back on. What about the antenatal visits? Who's going to be going? Are you going to be going to all of them? The scans, and critically at the birth, who's going to be there? Where is everyone going to be? It's essentially putting together the building blocks of your hospital plan. And then, obviously, the things that go wrong. What happens when things go wrong? If there is a miscarriage or a stillbirth, unexpected multiples, decisions around termination, decisions around the breakdown of any of the relationships, and how would you handle these scenarios? And these are tricky things to talk about, but they're important, and it's worth spending the time to bed this down. Obviously, then there's the legal implications. What are everybody's obligations in terms of the parental order, and does everybody know about them? And of course, expenses and costs, not just around the surrogate's expenses, but the surrogate's partner's expenses. How are the clinic fees going to be paid? When and how are those expenses going to be paid? And just drilling down in that detail. It's all going to be information that you may need for the parental order, but most certainly you're going to need, an understanding of how to budget for that. And a surrogate needs to feel reassured that you can make that commitment, and you obviously need to be able to be clear on to what your obligation is going to be as intended parents. Once this is all in place, it's really important to get it written up, signed by everyone. This really, really endorses it. And as Natalie said, each of the non-profit organisations will have a template for you to adhere to, or for you to draft yours independently from. Even if you're working with a surrogate independently, put it together. It really just is worth spending that time. And actually, if there are then misalignments, then pre-embryo transfer, you getting too far down the route, you can explore whether maybe this particular relationship isn't right for you. At Brilliant Beginnings, we match, for those of you who were in the talk a little bit earlier, we match very much on a one-to-one basis. So we want to get to know our intended parents and our surrogates. And we will only match intended parents and surrogates who are aligned in the big stuff as well as the soft stuff. So that by the time you get to putting together your agreement, we don't expect any surprises. That said, we still are belt and braces, and we sit down with our intended parents and surrogates and have a mediated agreement meeting where we will go through the whole thing with a fine-tooth comb. That's how important it is. And, you know, what we're aiming to do with all of this is have your journeys just go as smoothly as possible. You know, nature is always going to throw us curveballs, and we want to try and minimize that. You're going to want to try finally, and maybe think about reviewing your agreement with your surrogate. In the instance that, you know, maybe you've achieved a successful pregnancy and you're going on to a sibling journey. This is your baseline, if you like, for you to explore again. If you had reached the end of the particular terms of that agreement, say you agreed 3 cycles, you reached the end of that, that's always a good time for everybody to be able to draw breath, look at the whole structure of your arrangement, what needs to be changed, and if you're all happy and if you're all still on the same page. Hopefully we'll get to the stage where, you know, there is a little bit more solidity around a legal agreement of some form here in the UK. But in the meantime, don't ignore it. It's really important.